From Studio 226 in Orlando, this is Aging Smarter. Aging Smarter is a podcast focusing on making it easier to grow older and to prepare for the future at any age. We aim to educate, to entertain, prepare, and amaze you about your life's journey regardless of your age. I'm your host, retired and former Circuit Judge Jose R. Rodriguez. The R stands for Ramon, and you can roll your R's if you want to or you don't. But if you roll your R's with Ramon, you've got to roll it with Rodriguez. All right. To the folks that are watching and listening, please like and subscribe to this channel. You can also find these episodes by going to the website of the Senior Resource Alliance. All right, people. On today's podcast, I'm going to go ahead and push that button that says Professor Mode. And in Professor Mode, that means that even if it gets a little bit of yawny, please bear with me because we'll go ahead and course through the statutes, and then I will tell you how the statutes apply to real life, to aging, so that you can age smarter. I hope that our previous podcast conversation with attorneys Lori Loftus of the Office of Regional Conflict Counsel and practicing attorney Pam Martini has helped you understand some of the issues and the questions you might encounter in guardianship. Now, naturally, Aging Smarter does not endorse the attorneys as their opinions are their own opinions, and they provide a source of information that you might use to formulate your own questions about your particular circumstances when you hire counsel to assist you in your case. Now, I felt it was necessary to center this podcast on the applicable guardianship statute because we spoke with a certain familiarity about the process, which lawyers and judges usually do. And I sensed that it would be helpful to any consideration or study of Florida guardianship concepts to include a new, more in-depth discussion about some of the statutes, some of the quirky things that we're talking about. So first, let me tell you that we will take up the discussion of two different general types of guardianships. Those dealing with incapacity, they're governed by Chapter 744 of the Florida statutes, and those dealing with disabilities, governed under Chapter 393, also of the Florida statutes. Hopefully, by the end of the podcast, you're going to have this aha moment that comes with understanding how capacity and disability differ in the guardianship weeds. So, let's put on our boots and head for the statutory guardianship weeds. In guardianship cases, we will find the definition of incapacity in Section 744.102. And that part of the statutes defines incapacity. Okay, now we're in the incapacity weeds. So let me read a particular portion of the statute. It says, as used in this chapter, the term incapacitated person means a person who has been judicially, that means the judge, has determined the person to lack capacity to manage at least some of the property of the person or to meet the essential requirements for health and safety. Okay, manage property. Meet the essential requirements of health or safety. Important concepts. Manage property means to take the actions necessary to obtain, administer, dispose of real property, personal property, intangible property, business property, benefit property, and income, any kind of property. And if you can't do that, the court will go ahead and find you incapacitated and appoint a guardian of the property. Now, the next part of the statute says to meet the requirements for health and safety. That means to take those actions necessary to provide for the health care, food, shelter, clothing, personal hygiene, or other care without which serious and imminent physical injury or illness is more likely than not to occur. That means you can't take care of yourself. You don't know up and down. If you've got medication, you're not taking it the way you're supposed to. It just means you can't take care of yourself, your health care. So if the court finds you incapacitated because you can't take care of your health care and safety, then the court will appoint a guardian of the person. Okay? We saw that if you can't take care of the property, you get a guardian of the property. If you can't take care of your person, guardian of the person. What if you can't take care of both? Well, then the court will go ahead and appoint what is called a plenary guardian, which means plenty of stuff, which means everything in every area, your rights will be taken and they will be delegated to a guardian. Now, that's a guardian who is supposed to make sure that they behave, they act, and they take action in your best interest. Now, these definitions of caring for one's property or one's person form the focus of the incapacity inquiry that the appointed lawyers and the examining committee are there to assist the court in its determination, which may ultimately result in the removal of rights and delegating them to the guardian, as I just mentioned. This process starts when a petition to determine incapacity is filed, along with a petition to appoint a guardian. After these petitions are filed, the court appoints a lawyer to represent the person who is alleged to be incapacitated. Imagine that. Lawyer gets appointed to help you keep your rights in the event that there's an issue where incapacity is not, proven by clear and convincing evidence. That attorney is usually from the Office of Regional Conflict Counsel, like Lori Loftus was. Next, a 3-person examining committee is appointed. This examining committee is required to report to the court, and a report to be filed after the examining committee visits the individual that's alleged to be incapacitated. In fact, that process can be found and is detailed in 744.331. Let me give you the numbers, because if you're like me, math is not necessarily your strongest suit. 744.331 of the Florida statutes. Now, that statute starts in pertinent part with providing for due process. What's due process? Well, due process is a required notice and an opportunity to be heard, along with a right to counsel. What are you noticing? Well, I'll tell you that in a minute. What is the opportunity to be heard? I'll tell you that in another minute. Notice and an opportunity to be heard are absolute constitutional rights that no one can take away. Well, supposedly. But the system is there to provide protections, and that's what due process does. It provides protections by allowing you to put your best foot forward, to respond to the court, any allegations that are made of incapacity, if in fact there is no incapacity. And what's at stake here is a loss of civil rights by a person, rights that are delegated, that are taken from one when found incapacitated, and then delegated to someone else. Imagine that. You have rights, they're taken away from you because somebody finds you're incapacitated, and then they give them to somebody else. Hopefully they will exercise on behalf of that person those rights smartly, knowingly, and because, again, as a fiduciary obligation, these guardians are required to act in the best interest of the individual whose rights they've just taken over. And again, going back to the definition of incapacity, these guardians would be appointed in the event that they can't take care of their property, they can't take care of their health and safety. These proceedings begin with a notice to the person and the appointment of counsel, as I mentioned. The statute reads as follows. Bear with me. You'll see this is very interesting. Notice the filing of a petition to determine incapacity and a petition for appointment of a guardian, if any, and copies of the petition must be served on, tricky words, served on, and read to the alleged incapacity person. What does that mean? Served on doesn't mean you're going to get a plate of spaghetti and you get to eat, your notice. What they do is you get a copy of the petitions that have been filed against you, and someone reads them if you cannot. If the person is actually someone who is truly incapacitated, and we're going just through the rigmarole of the motions to make sure that there's some guardian that's appointed to knowingly, intelligently, and again, for the best interest of the ward to exercise those rights, well, all that needs to happen is for that lawyer to read and explain the petitions, and to explain that if the person is found incapacitated, the court will adjudicate the person incapacitated and will appoint a guardian. In other words, serving and explaining is just that, letting someone know what it's about, what the process is about. Now, the notice is required to state the time, the place of the hearing, because there's going to be a hearing to inquire into whether or not the person is capacitated or not. Okay? So, at the end of the hearing, the court will have heard or have read the advice of the individuals that are making up the examining committee. So, we've been in the weeds talking about disability, and we've been in the weeds talking about incapacity. We've been talking about those two concepts and how they absolutely focus the court on what to appoint, a guardian or a guardian advocate, a limited guardian of the person, of the property, or a plenary guardian or a guardian advocate without the decision on incapacity. So with these additional statutory references and this analysis of the weeds of incapacity and disability, we hope that this will help you study and understand how these different statutes come to assist those who need them. Remember, Florida law and the Florida probate rules require that you be represented by counsel. There are some limited exceptions that the court has to get into. But, well, now that we've come to the end of our walk in the statutory weeds of guardianship, we need to thank some folks. First of all, we thank the Senior Resource Alliance, on whose website you can find our podcast, along with YouTube at Studio 226, Aging Smarter. My thanks and grateful appreciation to our showrunner, Art Miles, without whom our studio would not exist or run, and our Aging Smarter logo designer, Annie Newbern. This is a wholly volunteer-operated podcast for the benefit of the community. While the information is not intended to provide legal advice, it is provided as education, entertainment, and as a platform for public service. To the folks that are watching and listening, please like and subscribe to this channel. You can also find these episodes by going to the website of the Senior Resource Alliance. Join us once again next time for another episode of Aging Smarter from Studio 226 in Orlando.